So far we've been talking about the process of going through the arrest, the investigation, and how do you get to that point. Essentially what happens is the event happens, the crime, whatever happens, the police will do an investigation. They will execute warrants in order to do a search or a seizure. They'll question people. They'll do all of the things that are necessary to gather the necessary facts. If they have enough evidence, they will make the decision as to whether to arrest the person. If they arrest the person will go through the booking process. The booking process is simply taking the vital statistic type information from the individual. From there, the individual will then go into the court system itself. Once the police have completed their investigation, the evidence is turned over to the prosecutor's office, period. The prosecutor decides whether to move forward with the charges, period. If so, the defendant's first step in the legal procedure is to attend an initial appearance, period. At this initial appearance or arraignment, the purpose is to ensure that the person has not been illegally detained. This is important in terms of a first step to make sure that the person is the right person, has been charged with the right particular crime, and it really is just to make sure that we are starting off in the right procedure. At the arraignment, bail will be set if appropriate. If bail is set, the person is able to leave and return back to the court for the following proceedings. If bail is not set, the person is remanded back to the prison or back to the jail. At the initial appearance, in misdemeanor cases or less serious cases, a person may be asked to plead. The person may plead guilty, not guilty, or nolo contendere, i.e. no contest. In many felony cases, the person will not be asked to plead at this initial arraignment. For felony cases, the next step in the process is a preliminary hearing. This is scheduled very quickly after the initial arraignment so that the prosecution can present evidence to the judge to establish that they have enough evidence to continue to move forward. At the preliminary hearing with the judge, people may testify. The police officer is typically a person that will testify who was involved in the investigation. The burden of proof is not as severe as it is at the hearing or at the trial itself. Instead, this is a very similar burden of proof to that which is used in civil cases. It is merely a preponderance of the evidence that has to be proven in order to continue to detain the individual and to move forward at this point. So the prosecution only has to convince the judge, has to tip the scale in the prosecution's favor, so maybe 51% sure that there is at least enough evidence to continue on. It is not uncommon that a defendant might waive the preliminary hearing. This simply means that they do not want to go through that step. They are admitting that there is at least probable cause, but this is not by any means an admission of guilt or an admission that they do not want to have any of the other proper procedures followed. Throughout this process, there's also negotiations going on in order to settle this case. In criminal cases, they will work out a plea bargain with the defendant. This can happen from the time that the prosecution gets involved all the way up to the time of the actual sentencing after trial. So at any point in this time, there is negotiating throughout. After these initial steps, if the person has pled either not guilty or has not been able to reach a plea bargain, they will continue on to trial. At trial, they go through the process, which we'll talk a lot about, but as a result of the trial, the jury will decide whether the person is either guilty or not guilty, in which case, if they are not guilty, they will grant an acquittal. If they are guilty, they go through another process. They can accept